Understanding words is what you really need to start doing. You need to start doing your homework and understanding words. If you put an S in front of words, it becomes swords. And that's what words are. They are cutting. They can cause you great trouble. Humans are word-controlled creatures. So we need to establish what words mean. When we talk about law, there's a Roman maximum in law that says, "For he that would be deceived, let him." Simply meaning, if you are so ignorant as to be deceived, then that's your business, that's your problem. So you need to do your homework and find out what the words mean, especially in relation to law and government.
Joinder. In law, a joinder is the joining of two or more legal issues together. Procedurally, a joinder allows multiple issues to be heard in one hearing or trial and is done when the issues or parties involved overlap sufficiently to make the process more efficient or more fair. It helps courts avoid hearing the same facts multiple times or seeing the same parties return to court separately for each of their legal disputes. The term is also used in the realm of contracts to describe the joining of new parties to an existing agreement. Criminal procedure. Joinder in criminal law refers to the inclusion of additional counts or additional defendants on an indictment. In English law, charges for any offense may be joined in the same indictment if those charges are founded on the same facts or form or are a part of a series of offenses of the same or a similar nature. A number of defendants may be joined in the same indictment even if no single count applies to all of them, provided that the counts are sufficiently linked. The judge retains the option to order separate trials. Civil procedure. Joinder in civil law falls under two categories: joinder of claims and joinder of parties. Joinder of claims. Joinder of claims refers to bringing several legal claims against the same party together. In the United States federal law, joinder of claims is governed by Rule 18 of the Federal Rules of Civil Procedure. These rules allow claimants to consolidate all claims that they have against an individual who is already a party to the case. Claimants may bring new claims even if these new claims are not related to the claims already stated. For example, a plaintiff suing someone for breach of contract may also sue the same person for assault. The claims may be unrelated, but they may be joined if the plaintiff desires. Note that joinder of claims requires that the court have jurisdiction over the subject matter of each of the new claims, and that joinder of claims is never compulsory. A party who sues for breach of contract can bring his suit for assault at a later date if he chooses. However, if the claims are related to the same set of facts, the plaintiff may be barred from bringing claims later by the doctrine of residential judicata, e.g. if a plaintiff sues for assault and the case is concluded, he may not later sue for battery regarding the same occurrence. Joinder of parties. Joinder of parties also falls into two categories: permissive joinder and compulsory joinder. Federal Rule of Civil Procedure Number 20 addresses permissive joinder. Permissive joinder allows multiple plaintiffs to join in an action if each of their claims arise from the same transaction or occurrence, and if there is a common question of law or fact relating to all plaintiffs' claims. For example, several landowners may join together in suing a factory for environmental runoff onto their property. Permissive joinder is also appropriate to join multiple defendants, as long as the same considerations as for joining multiple plaintiffs are met. This often occurs in lawsuits regarding faulty products. The plaintiff will sue the manufacturer of the final product and the manufacturers of any constituent parts. The court must have personal jurisdiction over every defendant joined in the action. Compulsory joinder is governed by Federal Rule of Civil Procedure 19. It sometimes makes it mandatory that some parties be joined. Parties that must be joined are those necessary and indispensable to the litigation. The rule includes several reasons why this might be true, including if that party has an interest in the dispute that they will be unable to protect if they are not joined. For example, if three parties each lay claim to a piece of property and the first two sue each other, the third will not be able to protect his alleged interest in the property if he is not joined. Another circumstance is when a party might end up with inconsistent obligations. For example, he may be required by two different courts to grant two different parties exclusive rights to the same piece of property. This is avoided by joining the parties in one lawsuit. However, while necessary parties must be joined if that joinder is possible, the litigation will continue without them if joinder is impossible, for example, if the court does not have jurisdiction over the party. By contrast, if indispensable parties cannot be joined, the litigation cannot go forward. Courts have some discretion in determining what parties are indispensable, though the federal rules provide some guidelines. Contract law. Joinder agreements are commonly used in mergers and acquisitions to bind individual shareholders to the terms of an existing merger agreement or shareholder agreement, and in trust practice to bind a donor to the terms and conditions of the trust. Timing. Rules 18 and 20 have different effects depending on when they are invoked. Joinder may occur as part of an original pleading. There is a discretionary period after the initial filing, during which original pleadings may be amended as a matter of course. Parties or claims or both may be joined during this time. However, if the time for modifying the pleadings has passed, the pleading can be amended with the permission of the opposing party or the judge, though this permission is frequently granted. Rule 15 describes the process for amending a claim. Under Rule 42 of Federal Rules of Civil Procedure, the court, if actions involve a common question of law or fact, may join any or all issues, consolidate the actions or issue any other orders to avoid unnecessary cost or delay. The court may also order a separate trial of one or more separate issues or claims for convenience, to avoid prejudice, or to expedite or improve economy. Joinder of action. Under certain circumstances a plaintiff may join several causes of action, or claims for relief, in one complaint, declaration, or petition, even though each could have been the basis for a separate lawsuit. This procedure is not the same as the common one in which a plaintiff relies on more than one theory of recovery or mode of redress to correct a single wrong. To determine if the plaintiff is joining separate causes of action, as opposed to merely pursuing more than one means of redress, some courts look to whether the plaintiff is seeking to enforce more than one distinct primary right or whether the complaint addresses more than one subject of controversy. Other courts look to whether the claims emanate from a single occurrence or transaction. If the court's inquiry shows that a plaintiff is attempting to join several causes of action into one lawsuit, the court must look to the applicable court rules and statutes to determine if such a joining is permissible. Modern statutes and rules of practice governing joinder of causes of action vary by jurisdiction. In general, however, they are liberal and encourage joinder when it promotes efficiency in the justice system. For example, the Federal Rules of Civil Procedure provide that a plaintiff may join in one suit as many claims as she or he has against an opposing party. Some state rules are similarly broad. Many states provide that the court, on its own motion or on the motion of a party, may consolidate similarly related cases. Joinder is not always favored by modern rules of court and statutes. Some statutes will not permit the joinder of causes of action that require different places of trial. Also, the various joinder statutes generally provide that inconsistent causes of action, that is, ones that disprove or defeat each other, cannot be joined in the same lawsuit. For example, a plaintiff may not in a single suit rely on a contract as valid and also treat the same contract as rescinded. However, contract and tort actions may be combined in one suit when they arise out of the same occurrence or transaction and are not inconsistent. Misjoinder. Misjoinder is an objection that may be made when a plaintiff joins separate causes of action that cannot be joined according to the applicable law. Some states require the plaintiff to decide which of the misjoined claims he or she wants to pursue. Other states allow the court to sever the misjoined claims into separate actions. Joinder of issue at common law. Joinder of issue occurs when one party pleads that an allegation is true and the opposing party denies it, such that both parties are accepting that the particular issue is in dispute.